My name is Fatimah Najwa binti Kamsani.
My name is Nur Nazira Najiha binti Muhammad Khairul Anwar.
My name is Syed Muhammad Faris bin Muhammad Zaidi.
My name is Alia Nafisa binti Ahmad Tarmizi.
My name is Intan Safina binti Muhammad Sabri.
Sekolah Agama Menengah Nur Iman.
Madrasah Al-Atas Al-Arabiah Johor.
SMA Ma'anul Fazliyah.
Sekolah Raja Perempuan Takyah.
Sekolah Raja Perempuan Takyah Ipoh Perak.
Inspired by Harvey Specter in TV drama, he fight for what's right and make career difference. Especially in today's world where everything can become unfair, I want to navigate those challenges and be someone who can speak up for others.
It's actually from my mother, who is real estate agent, who work really close to a lawyer.
I've always been passionate about justice, critical thinking, and helping others to understand their rights. Helps me to make meaningful contribution to society.
Because of my father, he's not a lawyer, but he's a staff at the court. So I grew up following him to the office and see how the court it is. I think it's easier for me to study and work in a law field.
During high school, I was put in religious classes where most of the subject is in Arabic and I required a lot of memorization skills. I think by choosing law, I can survive with my experience of memorization.
Pursue my study in degree in law.
To further my study in degree,
To further my studies into degree,
pursue degree in law.
Pursuing Bachelor of Laws.
Maybe I want to become a lawyer.
Work as a legal advice to any company.
become a legal practitioner.
To become a lecturer.
Become a corporate lawyer.
Research for cases.
Improve my communication skill, especially with my friends and teachers.
Answering law questions.
Learn how to do a citation case.
Searching legal databases such as LexisNexis and CLG.
Assalamualaikum. As your legal associate, I have reviewed about the fact of your transaction with SmartStop and analysed based on Malaysian contract law, particularly in relation of misrepresentation, exclusion clauses and remedies. So I will briefly summarise about the fact you give me before. So you have entered into a business contract with SmartStop for an AI-based inventory management system which claims that cut waste by 19% using AI forecasting used by top brands across Southeast Asia. You were pushed to make a quick decision by a two-account left promotional banner. The process did not allow fully review the terms unless you click buy now. So you pay 4,500 ringgit using company card and accepted the terms through a click wrap agreement. However, the software turned out to be a basic manual tool. When you tried to cancel, the company refused, relying on a clause that disclaimed liability for marketing claims. So my purpose to advise you today is to help you understand whether your consent to the contract was valid, advise you whether misrepresentation occurred, analyze if the exclusion clause can legally protect SmartStop, outline your possible legal remedies including the potential for a refund or damages.
So now, I would like to talk about misrepresentation that happened in your situation. Misrepresentation can be defined as giving false statement or misleading statement that made by one party to another party. Under Section 18 Clause A, Contracts Act 1915, state that misrepresentation includes positive assertion in a manner not warranted by the information of the person making it, of that which is not true, though he believed it to be true. One type that's suited in your situation, which is type of innocent misrepresentation. Innocent misrepresentation can be defined as the party believe that the statement is true, but it actually not true. So the first element is misrepresentation is a false representation made before at the time of contracting. In your situation, the advertisement state that there will be 90% AI forecasting that you will get if you buy the product. But unfortunately, when you buy it, there was just a normal Excel base that you get. So the second element is the representation must be one of fact. Here in your situation, we can see that in the advertisement state a fact that you will get AI forecasting. But when you receive it, it was no AI at all. So the third element is the maker addressed the statement to the party misled. So here, you can cancel the contract by the company and you also can seek for a refund. The last element is the maker believe in the truth of the statement. So in your situation, we can see that the company believed their advertisement was a true information, but it was unfortunately false. Therefore, they lead amount to actionable misrepresentations. Exclusion clause is a part of a contract that tries to limit or remove a person's responsibility if something goes wrong. For example, if the company isn't responsible if their service is messes up, but by just adding this clause, it doesn't mean it's going to be valid. So, there are three main rules for the exclusion clause to be valid. Firstly, it must be stated in the agreement. Next, it must be communicated. And lastly, it must be brought to the attention of the other party. So the first element is that the exclusion must be in the contract before both party agrees. In your case, the chatbot didn't show the full terms unless you click buy now. So you didn't even get the chance to read the terms before you click. So this is just like in the case of Oli versus Marlborough Court Hotel, where the hotel had a sign in the room with rules, but it was too late because they already made the contract at the front desk and the court said it was not valid. For the second element, it must be clearly communicated and not misleading. In your case, the clause was behind a paywall. You had to pay first before you seeing it. And that is not fair. And it reminds me of the case of Thornton versus Shoe Lane Parking, where someone didn't see the terms until after they paid. And the court said it was not valid either. Okay, for the last element, it must be properly brought to attention of the other party. In this case, the chatbot rushed you and didn't clearly show the terms. And that is not unfair. There's another case called Curtis versus Chemical Cleaning, where a lady was told one thing, but the contract said another. The court said that it was misleading, so they didn't accept the clause.
So the first one, under Section 19 of Contract Acts 1950, provides that when consent to an agreement is caused by misrepresentation. Second, Section 65 of Contracts Act 1950, the agreement is voidable at the option of the party whose consent was caused. The third one, Section 34 of Contract Acts 1950, if that consent was influenced by misleading claim, this section allows you to void the contract. This section supports your right to cancel the contract even though you click the click wrap, meaning that you agree. The last one, Section 37 of Contract Acts 1950. Mastok SDN BHD has failed to perform by not delivering AI-powered service as promised. You entitled to restitution to be put in the position you were in before entering the contract, including a full refund, 4,500 is for exclusion clause. Exclusion clause attempting to disclaim liability for marketing representation is unlikely to be enforceable in this case. It does not take your right to cancel the contract because you were misled as allowed in the Section 19 of Contract Acts 1950. You have the strong legal grounds to seek restitution and a full refund due to misrepresentations. The exclusion clause as presented does not shield SmartStop from accountability.
In conclusion, while the buy now button was clicked, it does not amount to valid consent, especially when misleading marketing and unclear terms are involved. The exclusion clause never clearly communicated, and false claim about AI features amount to misrepresentation under Section 18 of the Contract Acts 1950. As a result, the contract is voidable. You have strong legal grounds to cancel the agreement, claim a full refund of 4,500 ringgit, and seek damages for any losses you suffered. We strongly advise sending a formal letter of demand to SmartStop Cedar Berhad, supported by clear evidence such as promotional materials and receipts. Should they fail to respond, your next step should be lodging a claim through the Consumer Tribunal or initiating a court action. Thank you. That's all from our groups. Thank you.